Hello and welcome to See You in Court, the podcast that informs you about the Georgia civil justice system, what it means to you, and how it protects individual rights. This podcast is a collaboration between the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Your hosts are robinfrazerclark and lestertate, who are both past presidents of the State Bar of Georgia and currently serve on the board of directors of the Georgia Civil Justice Foundation. And now this episode of See You in Court.
Good morning, friends and lovers of the law, and welcome to See You in Court. I am robinfrazerclark, and with us here today, as usual, is our brilliant, well-traveled co-host, lestertate. Hey, Lester, how you doing?
It's great to be in Cartersville, Georgia this morning and recording a podcast that I understand enjoys some minor popularity throughout the cybersphere.
That's right. We're celebrating 5,000 downloads. And as my kids pointed out, probably shouldn't call it download. Shouldn't it be like 5,000 listens?
Yeah.
How about 5,000 likes?
Likes?
Yeah. No, is that asking too much?
Yeah, I'm not sure. But I mean, for those 5,000 people, I want to urge them to go out and exponentially spread the gospel of See You in Court that you and I regularly preach here, and maybe we'll be able to get an exponential following there.
Yeah, I was going to tell you, I know you've been traveling a lot this month. We were just talking about that, but I'm tired this morning because last night I went to the Earth, Wind, and Fire concert, and it was fabulous. But I'm now drinking a lot of coffee from our See You in Court coffee mugs, putting in a lot of caffeine into my system.
That's the music of our high school years, Robin.
Yeah.
You know?
Oh, I know.
And Robin, you are a shining star.
Thank you, Craig. Well, speaking of shining star, I would say right back at you, Craig. Today we are very excited to have a Georgia trial lawyer with us, Craig Jones, and I call him the official guru of governmental liability. And I think most Georgia lawyers would agree with me on that. He is the go-to person when there's any question at all about governmental liability, who you can sue, whether you can sue a particular type of government, how to do it. Craig is the guru. So let me introduce.
I think it probably is more accurate to describe it as governmental non-liability.
Non-liability,
because liability is exception rather than the rule. Unfortunately, the law has historically made it difficult to sue the king. It used to be impossible to sue the king. Now it's possible in very limited circumstances to do so.
Those circumstances are about as clear as mud, too.
Before we get into that, and we are definitely going to explore that, let me tell our listeners, Craig, a little bit more about you. Craig Jones is a North Carolina native who is a graduate of Brown University and Wake Forest University School of Law. He has been handling cases of governmental liability, or as he says, non-liability, since the 1980s, including 2 civil rights cases that Craig personally argued in the United States Supreme Court, Hope v. Pelzer in 2002 and Scott v. Harris in 2007. And we're going to talk about a little bit about both of those cases. They're fascinating. In addition to representing plaintiffs in police misconduct and other governmental liability cases, Craig has practiced extensively in the areas of personal injury, medical malpractice, product liability, and premises liability. After practicing for 29 years in Atlanta and 8 years in Washington, Georgia, Craig and his wife, Sharon, are in the process of moving their empty nest to Savannah, where he will continue to maintain a statewide tort practice with civil rights cases in all 3 federal districts of Georgia. Craig used to always have as his byline a city lawyer in the country. Interesting. I love that you say that about yourself. But Craig, welcome to the show.
And thank you. And I actually stole that line from Jim Martin when he was in the state legislature. And I was actually given testimony about governmental liability before a legislative committee. And Roy Barnes was on the committee and Jim Martin was on the committee. And both of them made comments, and another legislator who was a non-lawyer made some kind of wisecrack about you lawyers, and Jim immediately said, "Well, the difference is that Roy is a city lawyer in the country, and I'm a country lawyer in the city." So that always kind of stuck with me.
That's a good one. Well, speaking of that, I know you have testified in front of numerous state house, maybe even state senate committees on governmental liability throughout the years.
Once or twice.
I know you have. I've been personally involved in where you've helped us present testimony to folks at the Capitol. So thank you for all of that. I mean, that is volunteering your time to try to make things right for Georgia citizens under the law, and we really appreciate it. Tell us, Craig, tell us a little bit about your practice and how did you first get into this governmental liability practice?
Well, I went to a college where you sat under trees and read poetry. And so when I got to law school, I really wasn't disciplined. I didn't have the good study habits. And I think I was 134 out of 137 in my class. So I didn't have a job offer when I got out. I moved to Atlanta because I remembered why it was that I left North Carolina to go to college after I'd been there in law school for about 3 days. So I moved to Georgia, moved to Atlanta, moved from one shop to another, basically learned that I could make money doing settlement packages on whiplash cases. And that was basically what I did for the first 5 to 10 years of my practice. Is I took chiropractors out to lunch and I handled minor personal injury cases, much like the billboard lawyers do today. And then I had a case that wandered into my office where a woman had been, her husband had been shot by a Smyrna police officer on a DUI stop. And I'd always had an interest in constitutional law, and I was a history nerd. So that really, I think that was meant to be. And I associated Bobby Lee Cook on that case. I learned a lot of cool stuff. Next thing you know, I had other police shooting cases, other excessive force cases. And I would say for the last 10 years that 90% of my practice has involved either police misconduct or bad behavior by, some sort of government official who has, caused an injury.
Yeah. Let me ask you, I guess just because you've become the go-to guy, so I'm sure a lot of folks, other lawyers who don't do this kind of law, send clients to you. Can you talk to us a little bit about when a potential client walks into your office, how do you analyze a case like this? Let's talk about the fact that they're very difficult to begin with. So you are taking on a piece of law that the cards are kind of stacked against you from the get-go.
Sure.
Talk to us a little bit about how you go about analyzing a case when a potential client walks into your office.
Well, I'll be honest with you. I probably get 3 or 4 calls a day, and I probably turn down 95 out of 100, meaning without even an appointment. But what I'm looking for, first and foremost, is are there significant damages? Because I know it's going to be a difficult case no matter what. It's going to be hard, whether it's a small case or a big case. So if it's a big case that meets my damages threshold, then I move to the next question, which is, what do you think they did wrong? And unfortunately, the vast majority of the time, nobody knows what happened. It's somebody's kid and some cop in a dark alley, and there's no witnesses except the cop, and there may or may not be video. And I can't afford to have hundreds of open files sitting around so that I can investigate and determine whether it's a case or not. So I guess, maybe if you'd asked me this, it would have been a better question to ask me 20 years ago, maybe, when I was less selective about my cases. But what I'm looking for is damages, a case that I know has value, so that if we do win the case, it'll be worth the years of time and effort put into it. And that and then in terms of liability, I need to be convinced in my mind that it's a slam dunk case, because if I think it's a slam dunk case, there's maybe only a 50 or 60% chance that I'll lose it. Because, as Lester said, the laws are muddying this area. And for good reason. The law gives lots of leeway to police officers, gives them the benefit of the doubt, gives them all kinds of legal protections, because otherwise, anytime a police officer or any government official for that matter did something or failed to do something, somebody would be ticked off and somebody would want to sue. No matter what they do or what they don't do, somebody's liable to get hurt. So it has to be something that fits into a particular pigeonhole, that violates a particular constitutional right that's been, clearly established by law over the years. And you can look at a book and say, thou shalt not do this, and then make the case that the officer violated that rule, and then hope that the damages are enough to justify the years of work that it takes to get to that point.
So I have sort of a policy question for you, Craig. I recently, I was actually talking to our sheriff here from Bartow County. We were on a little fishing trip, and we were talking about qualified immunity. And of course, that we'll talk more about what that is later, but it provides specific protections that make it very difficult to sue a law enforcement officer that is in any way in performance of his duties. And he said, boy, if they ever do away with qualified immunity, I'm going to be out of this business. And I said, I kind of have this thought that one of the reasons that you see so many law enforcement officers being prosecuted is because the victim or the family's victim don't have a civil remedy. And so it really ramps up the pressure on district attorneys, U.S. attorneys to criminally go after somebody who got up that morning probably just going to their job like we go to their job, to our job.
Mm-hmm.
Do you agree with that assessment? Or
I absolutely agree with that assessment. I see police officers being criminally prosecuted for things that they can't be sued for.
Right.
And that's really because the criminal law doesn't have something called summary judgment. They basically, they put the facts in front of the jury, and the jury decides the facts. And too many times in civil cases, you've got judges looking at the facts, putting their own spin on it, and then deciding whether a jury ought to try the case or not. So, whenever there's a high-profile tragedy, there's political pressure that gets brought to bear on the prosecutors, on the police, on everyone to do something about it. And sometimes it makes more sense for a prosecutor to just put it in front of a grand jury and see what happens, as opposed to putting their head in the sand and not doing anything about it like they used to do. But my thought is that it ought to be easier to sue the police, and it ought to be harder to criminally prosecute them. And if anything, if they should have immunity at all, it ought to be in the criminal sphere rather than in the civil sphere. If a truck driver crosses a center line and wipes out a school bus, they don't get immunity for that. They do their job. The truck driver, is acting in good faith. He makes a simple error of judgment and kills people. And guess what? His insurance company pays for it. And that's really the way it ought to be with the law enforcement. And that's the way it is with Bartow County. They have insurance. It's who's your sheriff now, by the way?
Mark Millsap.
Yeah, I've sued him before. Tell him I said, hey.
Are there any of the 159 counties you haven't sued the sheriff, Craig?
There's quite a few. The one with Millsap, and it wasn't him personally, but it was a deputy who the
sheriff gets named even when the sheriff. It's
right, and that's partly that. That's part of that is because of nuances in Georgia law that we probably don't want to get too deep in the weeds on. But but it's, if you're talking about sheriff's deputies doing something wrong, the way Georgia law is, and the way a lot of states' law is, that the sheriff's deputies don't work for the county. They're considered a separate governmental entity. And then, but yeah, the county pays for the guns, the county pays for the training, the county pays for their wages, pays for their vehicles, and pays for their insurance. So the way the law's set up, and not just in that context, but in a lot of contexts, you end up having to sue a police officer individually for something that he or she did, and the money's not coming out of their pocket, and you cannot sue the city or county itself, because depending on what law you're working with, you likely may not be able to sue the agency themselves. So all you have is an individual police officer who's doing their job maybe in good faith, maybe not. And it's not clear that there's going to be a deep pocket there to stand behind them. And yeah, go ahead. I'm sorry.
It's all right. Interestingly, I watched the Georgia Supreme Court oral arguments yesterday. They were at John Marshall. I watched them online, John Marshall Law School. And this issue,
John Haddon's case.
John Haddon argued for the plaintiff yesterday on a Clayton County, Georgia case where they're saying county and sheriff should be basically the same entity for the exact reasons you've just said. They have the same insurance. They're part of the county. And so that issue is going to be decided, or at least a part of it's going to be decided by the Georgia Supreme Court soon, within the next few months.
Yeah, and that's a real narrow slice of the landscape here. There's so many different nuances to all this, but the irony of that case, and it will impact a couple of cases that I have that are pending on appeal. The irony is that you have the Georgia law, which says that sheriffs do not work for the county. You have a statute that says if you're suing the county, you have to give them notice within a year. And that statute doesn't say anything about sheriffs anywhere in it. So if sheriffs don't work for the county and you can't sue the county for what the sheriff does, why does that statute have anything to do with sheriffs? But the Court of Appeals has said multiple times that if you're suing the sheriff, you got to put the sheriff on notice within a year, just like you would if you were suing the county, even though the sheriff and the county are two different things. Essentially, it's a case of judges, blue penciling additional language into a statute to achieve what they believe is a fair result in a given case, where it may have made sense to do that at one point, but then it affects all these other cases.
Yeah.
And that's always a challenge if you're a judge. I mean, if you're a legislator, you're making broad rules that probably need to have loopholes and exceptions created by judges to achieve a fair result. But then on the other hand, whenever a court does that, then they create mischief for other cases down the line. And I guess that's why they have people like the three of us practicing law to, try to bridge that gap.
And the other thing is, and I want you to correct me if I'm wrong about this, but I totally understand our sheriffs, not wanting the qualified immunity, feeling like, it gives me some protection. And then, I have a sort of different take on that. Where you stand on something depends on where you sit, a lot of times. But we have done, like with the Georgia Tort Claims Act. Now, we specifically excluded law enforcement officers from the Georgia Tort Claims Act. But one of the things that was sort of an impetus for that was Department of Transportation engineers and highway designers getting sued all the time in an individual capacity for their negligence. And we set up a system where, and Robin and I both have I know, sued under this system, and I know you have, where you can sue the state and they're made the appropriate defendant. So all of this would be subject to a very clear legislative fix that could actually give the sheriffs and the law enforcement officers more protection than they have just with the qualified immunity. And get some justice for some folks too.
Right. For example, with automobile accidents, there's a statute, OCGA 36-92-2, that says that all cities and counties are required to provide a certain amount of insurance protection for car accidents. And you could you could simply change the word accidents for tort claims or personal injury claims. You could make that apply across the board for everything. And the statute says you can't sue the individual employee; you have to sue the agency, and it's for a set amount of money. Now, as it stands right now, in other types of cases, if other non-motor vehicle cases, if you're suing a police officer individually because they say assaulted your client or used excessive force, made a false arrest, whatever it happens to be, you have to sue them individually. And depending on whether you're talking about state law or federal law, there are certain immunities available to the officer. But if you get around that immunity, then there's no cap on the liability. There's there's no limit to the coverage, which means that if the county has $1 million in insurance and a jury awards $5 million to somebody that the officer kills, the officer is potentially on the hook for that $4 million. And then there's an issue of whether they can go after their insurance company for bad faith for not settling the case. But that's something that maybe it's too fine of a point for this discussion. But when you're talking about excess coverage and potential bad faith exposure for insurance companies, if you sue an officer individually, they have that. If you sue the agency itself, they don't, because the agency has sovereign immunity above the amount of insurance, and therefore there is no excess exposure. So potentially it could be better for the defense side and the insurance side too, if it was easier to sue and if you could just sue the agency and if the liability was capped, about a certain amount.
It sounds like the people that are really making out like bandits on this are the insurers for governmental entities, because they rarely have to pay and they still collect a pretty hefty premium.
Absolutely. In fact, I have a case right now. I got a default judgment against the city of East Point for $7 million. And it's what I call a triple crown default. The officers, I sued 3 individual officers. None of them filed an answer. I served the city attorney, and he sent me an email, "Thanks for calling this to my attention." And then I served the insurance company by certified mail, and everybody dropped the ball. Nobody filed an answer. The thing went to trial. 6 months later, I got a default judgment. Every possible I has been dotted and every T has been crossed. Then we waited out the appeal period. We waited out the term of court, and then we sent them a nice letter and say, that would be cash or check. So actually what we've done now is we filed a lawsuit against the insurance company on the policy to try to collect the judgment, of which they're fighting, of course, saying there's no coverage. They charged the city of East Point $1.6 million, taxpayer money, $1.6 million a year for an insurance policy that they say provides no coverage, because they said it was the city's fault that the case went into default and not theirs, because the city has a duty to defend and they only have a duty to indemnify. Which is crap, because it also requires the city to put the insurance company on notice of anything that, if it's more than 50, if the potential value of the claim is 50% of the self-insured retention or more, they want to provide a defense. And obviously the self-insured retention in this case is $150,000 and the insurance is $7 million. I don't think that's going to play well. But you that's an excellent point. $1.6 million for an insurance policy that has weasel words in it where they can claim they don't have to pay.
Right.
And that's taxpayer money that's paying for that.
Yeah, almost sounds fraudulent to me. I will be watching for that, Craig. That sounds very Very promising.
And how many hundreds and thousands of other cities have they done the same thing to? It's Chubb. I mean, it's a subsidiary of Chubb, which is one of the biggest insurance companies in the world. They got a lot of money sitting in Swiss bank accounts.
Because they spend more time collecting premiums than paying out claims, like most insurance companies.
That's right. It's a Ponzi scheme.
Craig, let's, for our listeners, talk a little bit about the different types of governmental liability, because it's so bizarre. As you mentioned, counties are sort of out on their own. We've got, for state, Georgia Tort Claims Act. For city, they have their own mechanism. Can we talk a little bit about state, municipal, and county liability and why they're even different in the state of Georgia?
Okay. Historically, cities or municipalities were treated kind of like corporations. They're creatures created by the state. In fact, they're called municipal corporations, whereas counties are subdivisions of the state itself. So historically, you couldn't sue the state, and because you can't sue the state, you couldn't sue the county. And then, with regard to municipalities, there were statutes over the years that said, there's one in particular that said, if a city has insurance, then they waive their immunity to the extent of insurance. They can be sued to the extent of their insurance. But if they elect not to have insurance, then they have immunity, the same as the city, the county, and the state. Now, there were some court decisions in the 80s that basically extended that principle to the state, to counties. They basically said school districts, they basically, for a few years in the 80s, there were a lot of cases that said, if you have insurance, it's insurance money. It's not the taxpayer money that you're protecting. And therefore, there's no policy. The policy in favor of sovereign immunity, which is protecting the person, the taxpayers, doesn't apply to the extent you have insurance. Then there were some political reforms from the right on there was a constitutional amendment in 1991 where voters were asked to approve a ballot measure that would, quote, make it possible to sue the state. And the actual language, the amendment made it impossible to sue the state. And the Supreme Court said, well, that's okay, because anybody could go down to the county registrar's office, pull up the actual ballot language themselves, and it didn't matter if the language on the voting ballot was misleading or not. I mean, I thought that was a crazy decision, but in a very broad, vague way, they were giving people, the legislature, the power to pass laws that would enable the student state, and they did pass such law. They passed the Tort Claims Act, but it's a political compromise. It's you have less rights to sue now that the voters voted to amend the Constitution in 1991. They have fewer rights to sue the state than they did in 1991, even though they voted in 1991 for the right to do something that they already had the right to do. and that's just politics. Go ahead.
Yeah, there's obviously a lot of politics involved in all types of governmental immunity, especially counties. We'll get to that. But while we're talking about state the state as a potential defendant, you have to sue under the Georgia Tort Claims Act. That's the only way you can sue. And damages are capped at $1 million per, I guess, cause of action or per incident. We argue sometimes per claim. We sometimes argue conscious pain and suffering is $1 million, and then death is $1 million, something like that. So
there was a case some years ago that Charles Mathis had down in Milledgeville, and they held that the claim of the estate for pain and suffering and other things was a separate claim from the claim for wrongful death itself, which was held by the surviving family. I'm not sure why they hadn't schmoozed some amendment in to fix that, but we don't want to give them any ideas. But yeah, and Lester kind of alluded to this before about the Tort Claims Act. When it was passed, there was a lot of political sausage making that went into it, and they wanted to make it to where you sue the agency and not the state employee, because if you have to sue an employee individually, it can affect their credit. It can keep them from being able to buy a home, just because their name turns up on a docket search, as being in a lawsuit, even though it's not their money involved. They didn't want the individuals to be stigmatized by the lawsuit. So they made it where you had to sue the agency. But then on the other hand, they put some exceptions in the Tort Claims Act and exclusions that just make it impossible to sue for certain things, like if you've got something against the police involving excessive force, assault, battery, false arrest, false imprisonment, malicious prosecution, or actually anything, and this is some really catch-all phrase, anything involving the method of providing law enforcement, you can't sue under the Tort Claims Act for that, which means, and I know why they did it. They were trying to get the act passed, and that was something that they agreed to sacrifice, because they said, well, you can always sue under federal law for that. You can always sue for federal constitutional violations. We don't need to have that under state law. Unfortunately, the federal law is, just as difficult for other reasons. So it's a mixed bag. In some ways, the Tort Claims Act was good for plaintiffs. In other ways, it was bad. If you have a case against the state patrol or the GBI, you're not going to be able to sue them under state law, because the Tort Claims Act says that state employees have immunity and you can only sue the agency. And it also says that the agency has immunity if what you're suing for is excluded under an exception in the act. So the only thing you can do there, ironically, is sue the individual state trooper, sue the individual GBI agent in federal court for violations of federal civil rights. And then you got to get around your federal offenses like qualified immunity. And then if you do that, ironically, the state's still going to defend them. The attorney general is still going to defend them. The same pot of money that it provides insurance under the Tort Claims Act also applies under the federal law if you're suing a state employee. But you're suing an employee, you're not suing the state itself. And you can't sue the state itself under federal law because of the 11th Amendment. You can't sue. And there's some other technical reasons for that. Under the Civil Rights Act, a state's not considered a person, but a municipality or county is. And I mean, it's that's why we have lawyers, folks, is to create.
You also, when you're
create ambiguities like that, and then to try to cut through them.
Well, my friend Robin Clark we were on a panel together about state tort claims one time, and she had a great line. She said, they've got this requirement of an ante litem notice, and it has to have certain things in there. And she said, does anybody know why they have these requirements? And nobody really raised their hand, and she said, so they can kick you out of court.
Exactly.
That's why they have them.
Yeah.
And you were talking, though, about the specifically, and it's the Department of Administrative Services for state tort claims that has the pot of gold that they pay out of if they want to settle stuff, or if they get a verdict and it finally gets affirmed.
It's a state self-insurance plan.
It's a self-insurance plan. And, I had a situation where I had the wrongful death, where you've got the two claims. You've got the estate claim and you have the wrongful death claim. And I got $1.1 million on the wrongful death claim and $300,000 on the conscious pain and suffering, estate claim. And, even after the verdict came in, they kept trying to settle the case with me. And I thought they were going to pay me $1 million and we were going to, we were just going to kind of be done with it. And so it ended up I had the interest running on the judgment, and at the end of the day, I got the whole amount, caps notwithstanding, because I got the interest, off the thing. And so it was like $400,000 was a plaintiff's lawyer. And for my client, I'm very happy that I got $400,000 more. But as a taxpayer, they wasted $400,000 of taxpayer money, and not on a pre-suit settlement. I'm talking about one they already had a verdict, against them in, where there's sort of a, where it's been, there's a value sort of established for it.
Mm-hmm. Well, and I think that you make a fair point there about the waste. And one thing you can say about government is that they, in the self-insurance plans, is that they're not run like businesses. And if you got a commercial insurance carrier that's looking out for its own bottom line, they look at their own P&L statement more than government people care about taxpayer money, in my experience. And for example, I have a shooting case against Gainesville police officer, and it's insurance, One Beacon out of Boston, I believe. The vast majority of the cities and counties in Georgia that have insurance are insured through this self-insurance, this shared risk pool that's created by the legislature, which is essentially a trust fund where all these cities and counties pool their money, called GARMA or IRMA. ACCG, Association of County Commissioners of Georgia, has one, and then the Georgia Municipal Association has one. And they view themselves as trustees of the county money, and they will fight you to the end of time to keep you from getting that county money. And without regard for the amount of money that they end up paying lawyers to not pay us. I mean, I'd rather they pay us than pay their lawyers. But we have one where we have a law firm on the other side that's notorious for just, papering you to death, and all they do is file motions and claim and appeals and everything. And finally, we got to where we won the appeal, and we're on a trial calendar. And in other words, from our standpoint as plaintiffs, we're back to square one. We're back to where we started, which is we won our day in court and we still have to prove our case to the jury. So after 4 years of litigation, and the appeal says, yeah, you have a case that's good enough to go to a jury, they turn around and write us a check for the entire policy limits. We didn't have to fight for it at that point. They'll spend 5 years fighting to keep you out of court. And then once you get your day in court, they're ready to pay you. And that's because they're looking at it like a business. They're saying, okay, we're going to get creamed if we go to trial on this thing. These guys know what they're doing. They put up a good fight. We better pay them the money, or it's going to end up costing us more down the road. That's the way private insurance companies will work in this situation, more so than the governmental lawyers who, other case I had recently, a guy died in prison. Guy was electrocuted in his cell. Coroner termed the death a death by electrocution. No information was available whatsoever on how this guy electrocuted himself. I couldn't get anything under open records. We filed set up an estate for him out of state. We had the administrator, this where he was from. We had the administrator of the state subpoena documents. The state refused to produce them under some state secrets doctrine. Went all the way to the Court of Appeals. They said we weren't entitled to any documents. So guess what I did? I turned around and sued them under something called res ipsa loquitur. I said, there's no documentation on what happened. Nobody knows what happened. But people don't generally get electrocuted in the absence of negligence, And we're suing the people responsible for that electrical system, and we're going to get by summary judgment based on res ipsa loquitur because of that presumption. Immediately, the state turned over the documents that showed that my guy was fiddling around with an electrical outlet because he was trying to make toast from bread that he brought up from the mess hall. And they spent 3 years trying to keep me from getting information when all they had to do was give me a piece of paper to begin with that told me what happened. And I would have decided right then and there, this is a sad story, but it's not a lawsuit. And the reason it's not a lawsuit, even though there may have been some code compliance issues as far as the outlet and whether it was properly protected or grounded or whatever. Under state law, we've got something called apportionment and comparative negligence. And if the person who was killed in this case was equally at fault or more at fault, he doesn't get any money. And I didn't see any way that somebody who takes a plate off an electrical outlet and starts, fiddling with the wiring. How's that person?
That's a state secret that you revealed. Is how inmates in a penal institution make toast. That was a state secret,
Exactly. I guess they want the word to get out because other people might try to do it. I don't know, but it just an example. Actually, I wrote a letter, kind of a semi tongue-in-cheek, holding my nose letter to the baby lawyer in the Attorney General's office, thanking them for their professionalism in agreeing to produce that document to me immediately upon the filing of the second lawsuit. And then I totally reamed everybody else in the Attorney General's office for fighting me in 3 different courts to protect me from getting this information, which anybody should have a right to know. They want to know why their son is dead. And people that work for them, are paid by the taxpayers, hide behind these legal doctrines to keep people from finding out the truth simply because it's there. And simply because that rule is there. There's some Nimrod somewhere in a government building whose job is to enforce that one piece of, that one sentence, and to fight like hell to preserve it. And so anyway, I sent a copy of that letter to the other lawyers that had been involved in the cases. I sent a copy of it to the Attorney General. I sent a copy of it to the governor.
When are you expecting to get a reply?
Yeah, I'm sure the Attorney General has responded, right?
I did not get a reply. But here's what happened. The next time I had a case, I had the friendliest person. I had the warmest reception I've ever had from anybody in the Attorney General's office. So I know they passed that letter around and snickered about it. Let's just say that I've earned their respect by being an asshole, which is sometimes what you got to do. And I don't know if that gets edited out or not, but that is a legal term.
We have a regular PG warning here for our listeners. The similar sort of thing that I've run up on, Craig, is in equity cases like mandamus and stuff like that. The Attorney General's office and the governor's office. And I basically mean this going back a long way. This is not a political shot at anybody. This is every governor and every attorney general of every political party, has sort of taken the position that sovereign immunity protects from anything. No court can order us to do anything at all. They tried to pass a waiver of sovereign immunity just to get laws declared unconstitutional that were plainly unconstitutional and to attack other laws that were somehow violative. I think 2 different governors vetoed the legislation. So the legislature finally just took it as a constitutional amendment and it passed, and the entirety of the population of the state of Georgia voted to say, yeah, if you think a law is unconstitutional, you ought to have the right to sue the government and have a court pass on whether or not that law is constitutional. No money really changing hands at all. And, even after that, now I've had several cases where they go to the Attorney General office and they still claim sovereign immunity.
Yeah. And it's an example, again, of paying money to avoid paying money in litigating stuff in order to avoid the inevitable outcome. I mean, why don't you pay us now instead of later? But I don't know. Next question.
Let me ask you, Craig, out of state, municipal, and county liability, it seems to me counties enjoy more sovereign immunity than even the state or our cities. Why is that? And why did they get special treatment under Georgia law?
Well, historically, they were political subdivisions of the state. They had the same immunity as the state. But then when the State Tort Claims Act got passed, that only applied to state. It didn't apply to counties. There has been suggestions over the years that the Tort Claims Act ought to be amended to include counties, or that there even ought to be a local government Tort Claims Act. But there is a statute that provides that if a municipality, that is a city, has liability insurance, then they have basically made a policy decision that they want to provide protection for their citizens up to the amount of insurance, and the legislature recognizes that there is no similar statute for counties except as it relates to motor vehicles. There is another statute that applies to cities, counties, and school districts, which is OCJ 33-24-51, which says that they waive their immunity for motor vehicle claims to the extent of their insurance. And then since then, there's this other statute that's been passed, which is OCGA 36-93, no, 36 what is it, 36-92-1 and 2. Anyway, the statutory waiver of immunity says that all cities and all counties their immunity is waived up to $500,000 for one claim, or $700,000 total for motor vehicle accidents. But that only applies to cities and counties, does not apply to school districts. So it's a real patchwork, and a lot of it has to do with the political influence of people. Educators' lobby is very, very powerful. So they didn't want the schools to be opposed to that law, I guess. So they carved out the school systems, and school systems are probably harder to sue than counties in the state.
Let's talk just quickly about school systems, because I think to me, some of the most indefensible appellate opinions involve cases against educators. You can't, as you say, you can't sue the school system or the right. board, the school board. So you end up having to sue an educator who violated some policy or did something wrong that caused injury to a student. That actually happens pretty frequently. I know Lester has had a case like that, and I think got a pretty bad appellate opinion out of that case. I always talk about the case where a science teacher, they had a policy to wear goggles during science experiments, a school policy, and she didn't make every student wear goggles during an experiment. And guess what happened? Kid loses their eye. Right. Because the experiment explodes. And there's an appellate opinion that said she had immunity because enforcing a policy to wear goggles during an experiment was discretionary.
Right. She had to use her discretion to decide whether the policy applied or not. So
let's talk just a little bit about discretionary versus ministerial duties. And I always call ministerial duties, which you don't have immunity for, I call them the Loch Ness Monster, because you've heard about them, but no one's ever seen a ministerial duty.
Well, I've had experiences that have gone both ways on that, but your point's well taken. If you're suing an employee, a government employee individually under Georgia law, they have what's called official immunity if they are performing discretionary tax acts or let me phrase it the other way around. They only have liability if they're negligent in the performance of a ministerial act, which is a direct, specific task required by a rule or policy or practice that they don't have any discretion to deviate from. if there's a work rule that says this is the way you hook up the trailer to the earth moving machinery, whatever it is, and you don't do it that way, and somebody gets hurt, then yeah, they can be liable for that. But if it's not if there's no ministerial requirement, if it's not a rule requiring them to do something a certain way, and it requires them to use their discretion. And classic examples of discretion are things like disciplining students, disciplining and supervising school kids, or a decision to grant a permit or not grant a permit, those types of discretionary things. There's no liability for that unless you can show that they acted with actual malice. And that's a very nebulous term that means different things in different contexts. In the police context, there's a lot of cases that I rely on. A Supreme Court decision called Kidd v. Coates, a Court of Appeals decision called Gardner v. Rogers, that says that talks about self-defense, and there's a self-defense statute in Georgia that applies to citizens as well as police officers. And it basically says in this statute that you can only use deadly force to protect yourself or someone else against a deadly threat. And the Supreme Court in that case has said, or those cases said, if the facts are such that you're not facing a lethal threat, then you're not acting in good faith to where you're entitled to discretionary immunity. Essentially, you're acting with malice, because rather than acting in self-defense, you are acting with tortious intent. And he told me it's a little bit muddy here. And I'm not even sure it's correctly decided, the way they decided this in other areas. And I argue that all the time. When I have a police excessive force case, I'll sue under federal law for a violation of the Fourth Amendment. I'll add pendent state claims for assault, battery, negligence, whatever. And then if the federal claim gets kicked out because of qualified immunity, and more often than not, some of the more conservative judges, the ones who are more likely to throw out a civil rights case, more likely than not, will dismiss the state law claims without prejudice, because they tend to have more of a federalist ideology. And they give me a second bite at the apple to litigate that case again in state court. And I make an argument, and so far it's been working, that the Georgia statute says, it's got to be a lethal threat, and you have to use only that amount of force reasonably necessary to respond to the threat. When that necessary means if there's other alternatives that could have been done, like talking down the mental patient, de-escalating the situation, using a taser or something like that, even the mere fact that there are other alternatives would create a jury question under state law, in my view, as to whether it was reasonably necessary. And so I got a case right now before the Georgia Court of Appeals got thrown out in federal court. And my client, who got shot off a motorcycle in a Smokey and the Bandit situation because he refused to stop for Sheriff Buford T. Pelzer, 78-year-old sheriff standing out in the middle of the road wearing overalls in a pickup truck. My client sees him standing there with a shotgun, goes, "Oh shit," turns around, goes the other way. Sheriff shoots him off his motorcycle. That was deemed okay by the federal judge. But ironically, the judge down there, the Superior Court judge in this county, who sent my client to prison for a year for obstructing and fleeing and eluding the officers, that same judge denied their motion for summary judgment when I sued the sheriff in his court for using excessive force.
That's
so
interesting.
It's almost like the guy, and it's almost like the judge, he He knows the sheriff. He knows the sheriff's propensities, or did know his propensities. He's deceased now, by the way.
Or maybe had second thoughts about how everything went down.
Perhaps. Or you know what? Maybe he decided that justice would be to just let a jury of your peers decide the fate of both. I mean, my guy went to he didn't have to go to a jury. If he'd gone to a jury, he might have gotten 10 years.
Yeah.
But he entered a plea and was sentenced to a year, served 9 months. He definitely paid the price for his foolishness, which should not have included having, shrapnel in his skull for the rest of his life. The sheriff, on the other hand, if he's found to have acted unreasonably, the county's insurance company will have to pay my client a few $100,000. I mean, that's the way it ought to work, in my view.
So, but the way you're able to get that result is because of that Georgia self-defense statute, something there's actually really a policy of. But the case Robin, I think, is alluding to with me, which was, 15, 20 years ago, but a woman at the school back near athletic fields coming down a school road, and they have what's called a pole gate. Just these poles that they pull out there. Well, they had opened the pole gate, but they hadn't secured the pole gate back. And the wind, blew it out, and she literally got impaled with the pole gate coming through her window. And, guess what policies school districts have on whether or not you tie back your pole gate? Zero.
Right. It's not something that crossed the mind of the county attorney or the school board attorney when they were drafting up all these policies. Exactly. And also when they draft these policies, they always put these weasel words in the preface saying that this does not create a legal duty. These are simply guidelines, yada, 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 and the employee still has the discretion whether to follow them or not, even though they'll get fired if they don't.
Right.
But it's a challenge in every case. The only ones I've had success on making these kind of arguments are like water meter cases where, you got like it's common sense. If you take the lid off the water meter to read the meter, you're supposed to put it back on. To me, if it's something that if it violates one of the rules that you learned in kindergarten and you don't do that, there's a strong argument that can be made that that's ministerial. And so I have had 3 or 4 cases where people tripped or fell through unsecured water meter lids, and they ended up settling because you take the lid off, you got to put it back the way you found it. I mean, and there is a case. There's a case called, what is it called? Austin v. Glass, maybe? Glass v. something. There's a case involving hooking up some kind of equipment, backhoe or something like that, for a prison work crew. And this is one of the best cases to argue if you have one of these kinds of cases, is that if you have testimony from someone who works there that this is the way we do it, this is the way we're supposed to do it, we'll get in trouble if we don't do it that way. We ain't allowed to do it any other way. Well, guess what? That gives rise to a jury question. It's Glass v. Gates. That's the name of the case. Glass v. Gates. That gives rise to a jury question as to whether that's a ministerial duty. And it's hard to make it work, but it gives you a roadmap to do that. I lost a case where I tried that, and I think this exemplifies the problem you're talking about perfectly. I had a case where a Fulton County police officer accidentally shoots a kid. Kid's hiding in the woods. Kid comes out. He says, "Get on your knees." He gets on his knees. This is a 16-year-old, by the way. Puts his hands on the back of his head. And the police officer, seeing the blue lights circling the neighborhood and knowing that his backup's about to arrive, he wants to be standing there holding the trophy when they show up. So he decides to kick this kid, even though he's down on his knees with his hands behind his back. He decides to kick this kid in the back, push him flat on his stomach, and handcuff him before the backup, gets there so he can show off what a study is. When he kicks the kid in the back, it involuntarily causes his finger to pull the trigger and, shoots the kid in the head. And immediately, you can hear on the radio the cops going, "Oh my God! Oh, I'm so sorry. Stay with me, buddy. Stay with me, buddy." He's doing CPR. He's doing everything in the world that he can. And it turns out this is a white cop. It's a black kid. This is a white guy who went to the University of Georgia, majored in psychology, went into law enforcement because he wanted to help people, and he has a black wife and an interracial child. This is a 16-year-old black kid. He's just accidentally killed. No question in my mind that it was an accident. He didn't mean to do it. So Amy Totenberg rules. We file in federal court. We argue, first of all, it's intentional force because he shouldn't have pointed the gun at the guy, period. And by pointing the gun at the guy, and then it was foreseeable that could cause the gun to go off. So that was an intentional decision. That was an intentional use of force. She threw that out. She says, no, it's accident. It's not a constitutional violation. But under state law, he violated a cardinal rule of firearm safety. It says in the training materials, it says on a sign at the gun range. It even says it on a sign in the stall of the toilet at the police department's gun range. Rules of firearm safety. Number 3 is never put your finger on the gun and on the trigger unless you intend to pull it. This guy had his finger on the trigger. I argued that was a violation of ministerial duty. Guess what the 11th Circuit said? They said, no. The decision to make an arrest is discretionary, and therefore he has immunity. I mean, you can back something back far enough. The decision to get out of bed that morning was discretionary, therefore they had no duty. The Georgia law in that particular case, Glass v. Gates, says you look at the specific task which is closest in time and closest in causation to the injury. So they completely just screwed up their interpretation of Georgia law, even though I'd asked them to certify it to the Georgia courts. But guess what? When we came back down to the federal court, I was then able to appeal Judge Totenberg's original ruling that the shooting was not a constitutional violation, because you have to it's got to be a final judgment before you can appeal it in federal court, and that was just an interlocutory ruling. We got up to the 11th. This is one of my favorite stories. We got up to the 11th Circuit on the second case. My panel, I show up for oral argument. I'm looking at Ed Carnes. I'm looking at Joe Flatt, and I'm looking at a judge out of D.C. named Santel, who was the one that threw out the case against Ollie North. He's a darling of the Federalist Society. So I got the 3 most conservative judges I could possibly deal with. So I got up there and I said, would you believe that Amy Totenberg said that this was not a constitutional violation? And I honestly think they just reversed her because they couldn't agree with her on anything. But this was the argument. The argument was, just because the cop said he didn't mean to shoot didn't make it mean it was an accident. What if he, for a split second, intended to shoot, and then the second he did, he realizes, oh my God, I shouldn't have done that. Oh my God, I screwed up. You can't ask somebody whether they intended to kill somebody. That doesn't decide whether they get prosecuted for murder or not. It's something the jury's got to determine from all the circumstances. And there's a presumption in the law that you intend the consequences of your actions. So we went back to the worst panel imaginable. They reversed the decision by Amy Totenberg, saying there was no constitutional violation, and Fulton County paid me $2 million to settle that case. Even though if the jury had ultimately ruled that it was an accident, there would have been no liability at all.
And the classic there too, Craig, is that what you described actually happened, and I'm sure the anguish too that the police officer went through, just a truck driver that goes over the line. Mm-hmm. The truck driver would have been covered from day one. That case would have been clear liability, would have gotten settled without all of that.
Right. Instead, what happens is the case gets thrown out on qualified immunity. Everybody circles the wagon. They falsify police reports to cover the cop's ass, and then they promote him. That's how it usually works, unfortunately. I mean, that's the culture of law enforcement. Particularly,
what's the name of that case?
The name of that case was State, SPEIGHT, versus, at one time it was Fulton County. And Fulton County ended up getting out of the case, but I can't remember the name of the officer. Maybe that's a good thing.
Yeah.
The kid's name was Cunningham, and his parents, he was a minor, so his parents filed suit, and then the last name was State. But I do remember we got a structured settlement for the kid. And so even though he walks with a limp and he's not all there, he had some significant injuries. He's like the only 20-year-old kid I knew who, bought his own house. He actually bought a duplex. We actually had a special needs trust, which bought a duplex for him and his family. He lives on one side, the swinging single life. His parents live on the other side, and they're able to attend to his needs as necessary. So, I mean, I would prefer to have gotten 10 times more money than that, but that's how much insurance we were dealing with.
Craig, I do want to talk about the two United States Supreme Court cases you've argued.
Okay.
Because I may have told you this, but you're the only attorney I know personally who has argued in the United States Supreme Court. And that's quite an accomplishment, and you've done it twice.
Dave Walbert's done it 5 times.
Okay. Well, I do know David, but the difference is these were things where he was like representing the state or somebody in an action involving voting rights or something like that. And right.
Both of my cases are cases where I signed up somebody who was essentially a criminal on my little contingent fee agreement and worked the case from day one all the way to the end, and then argued it myself. So it's
amazing.
Not the typical case where you've got huge, lots of people, but battalions of lawyers, and then they pick the best person to argue the case. In fact,
they bring in other firms who have argued in front of the United States
you wouldn't
Supreme Court.
believe the people that were trying to argue the first case for me. It would people come all over the country were offering to argue my case for me for free and all this kind of stuff. And I said, I'm sorry, damn it, it's my case. I want to do it, and if it's going to be lost, I want it to be my fault. And then the second time, but I got a good result in that case. And then the second time, no one ever approached me. Apparently, there's this whole little clique out there of Supreme Court litigators, and they immediately, when a case goes up, they immediately check the background on the person, and they all start trying to figure out how they can get in on the action. Well, the second case I had, nobody did that because I had a track record from the first one, I guess. Fortunately, the first one I won, and the second one I lost.
I understand. That helps. Yeah, that's right. The first one, let's talk about Hope v. Pelzer, 122 S Supreme Court 2508, a 2002 case, I believe brought under the 8th Amendment, cruel and unusual punishment.
Yes.
And that was where your client had been tied up to a hitching post in prison.
Chained to a metal post.
I call it a hitching post. Was that what it was called in the case?
That's what we call. I mean, that's what we called it. That's what the media called it. The Department of Corrections was trying to call it a restraint rail or something like that. But essentially, this was all political too. There was a governor back in I guess it was the 80s and early 90s, named Fob James, who was very, wanted to be very tough on crime, and
he was Vince Dooley's roommate at Auburn, as I recall.
Was he really? Yeah, really.
Yeah.
Okay, well, he was this guy. They called him Wallace Light over in Alabama, but he was this guy was he wanted to be tough on crime, and he vowed to bring back chain gangs, and he did, even though they'd pretty much vanished in the 1930s from the American landscape. I'm talking about the chain gangs where they're literally chained together.
Cool Hand Luke. Cool Hand Luke.
Exactly. And
picking up here, boss.
In fact, I actually made a Cool Hand Luke reference at one point in the oral argument. It was either in the oral argument or it was in a news interview about it. I don't remember, but basically what happened is they brought back the chain gangs, and they decided that in order for the chain gangs to work, if the inmates refuse to work, what are they going to do? So they devised this draconian punishment for them that if they're not willing to work their job is going to be to stand out in the prison yard chained to a pole all day. Either way, they're going to work. They're going to do their job, or they're going to sit out there and be restrained. They're going to have no food or water. They're going to have no bathroom breaks, and they're going to stay chained to that pole until their crew comes back in at the end of the day. And the Southern Poverty Law Center had filed a class action to stop the chain gangs, stop the use of the hitching rail, some of these other practices that were going on, and they had success in that class action. But then there were maybe a dozen people who had suffered significant injuries as a result of being on this hitching post, and so they referred those cases to me to handle as damages claims. So they really did the hard work as far as getting injunctive relief and stuff like that. But I got the glory because when one of my cases went up to the Supreme Court basically said, you can't do this. And at that point, they had already stopped doing it, but I got credit for stopping it. In fact, I took credit for stopping it one time when my wife and kids were driving down to Biloxi, Mississippi one time to freeload on a casino that gave us a free room for the weekend. We went down there late on the beach for a weekend without spending one dime in the casino. And on the way down there, we pulled off at Monroeville, Alabama, because my wife wanted to see if Harper Lee was at the Hardee's, because she'd heard that's where she had breakfast. So we go down there. There's no sign of Harper Lee. And we get back on the highway, and as we're heading south on I-59 or 65, whatever it is, 65, I think, I see this water tank over the trees. It says Limestone Correctional Facility. I'm like, that rings a bell to me. Where do I know that from? All of a sudden, I realized that was where Larry Hope, my client in the Supreme Court case, had been. And as we get closer to the prison grounds, I see two wooden posts in the ground about 8 feet apart that used to have a metal rod across them that they chained people to. And the rod was gone, but the metal posts were still there. And so I looked at my kids, and they were like 8, 10, and 12 at the time. And I said, you see those two posts in the ground over there? There used to be a metal pole between them. And if the prisoners didn't want to do their job, they would chain them up to that pole as punishment. And your dad went to Washington, D.C., to the U.S. Supreme Court and made them stop doing that. And my 12-year-old says, what'd you do that for? And ironically, that's the one that is the one kid who's had the mental health issues and the problems with the law. The rest of them turned out to be completely straight-laced.
Well, that Hope v. Pelzer case was a case that made it clear that correctional officers have to be on notice that their conduct is unlawful at the time that they do some incident. And I think you argued kind of the common sense. Everyone should know that chaining a man up to this hitching post in the middle of the day with no water, no food, no bathroom, that's cruel and unusual. That violates his constitutional right.
Right. And that was actually the Cool Hand Luke moment, was that when Mr. Hope was out on he was actually there for 2 days for some reason. And the second time he was out there, it was hot, and one of the guards came up to him and with a bucket or a pail of water, and asked him if he wanted to drink some water, out of the bucket like an animal. And Mr. Hope said, "Yes, sir. I'm not too proud to do that." So then he puts the bucket of water at Mr. Hope's feet, and he's chained to this post. And by the way, the New York Times happened to be there that day doing an article, and there's actually a photograph in the New York Times of Larry Hope chained to the post, which was kind of nice, a nice little visual aid to have. My client on the front page of the New York Times, or on the front page of a section of the New York Times. Well, anyway, the guard whistles, and the prison dogs come running over there, and they start drinking out of the bucket. And then the guard picks up the bucket again, holds it up to my client's face, and he said, "You still want to drink the water?" He said, "Yes, sir. I'm not too proud to drink after a dog." And then the guard turns the bucket upside down, dumps the water out, and leaves. And then when he's leaving at the end of his shift, he's driving out the road in his Jeep with no top on it, blowing the horn, shooting the bird to Larry Hope. So this is what this man had to endure. And of course, we didn't sue that guy. I have no idea who he was. We basically just sued them for restraining somebody as punishment for something that they did or didn't do previously. You can only use force or restraints long enough to accomplish a legitimate purpose, but you can't prolong it. You can't use it gratuitously for punishment. And that's essentially what they said. And the place where the rubber hits the road in that case, and in all qualified immunity cases, is the only way you can recover damages for a constitutional violation is if the law has already been clearly established that what happened in this case is unconstitutional. And guess what? There's never been another case where people were chaining people to poles and, kicking over buckets and making them drink after dogs or anything like that. So the Supreme Court basically said, well, some things were just so obvious that you don't need to have a prior case on point. And so that's opened up, it's created a big area, which a fertile ground for litigation, because so many cases get thrown out of qualified immunity because the plaintiff can't find a prior similar case. But some things are so obvious, or they violate a rule from a case involving different facts, but it applies with obvious clarity to the facts in this case. So it is an end run around qualified immunity that works sometimes. But going back to my original point, when we first started this discussion, I said that if it's a case that I think is a slam dunk, I still lose it 50 to 60% of the time. That's because of this qualified immunity defense. And the way I look at it is if this was baseball, I'd be in the Hall of Fame. I'd be Ted Williams or Ty Cobb. I'd be batting, in the 400s.
Sure.
But that's completely unlike every other area of plaintiffs' lawyering. These guys with the big faces on the billboards, they're taking clear liability cases. It's just a question of how much money, they're going to get for their client. Right. And most lawyers won't take a case at all unless they think they're 90% chance of winning. I take a case that I think I've got a 90% chance of winning, knowing that I still good chance I'm gonna lose it. But it's because I'm my intellectual interest in this area of the law and wanting to live in a fair and just society.
Well, I agree, and I've had a
being a nerd, a constitutional nerd.
As you know, I've had a couple of prison cases, and what I've argued about an officer knew that his conduct was unlawful. My standard is if you wouldn't do it to a dog, then it's unlawful. And I had a case where my client they left him. He attempted suicide by hanging. Guards come in, and we've got this on body cam. They see him hanging and leaving. and talk about it and go get a camera and all this, and they leave him hanging. Finally, some other guard comes in and says, "What are you guys doing? Get him down," which they did, and he was alive, but now brain damaged because these other guards watched him hang. And my argument was, if it'd been a dog, they would have gotten him down immediately. It's sad that that's the standard we have to have for prison correctional officers, but that unfortunately it is.
And it's a deliberate indifference standard. They have
it is deliberate indifference. Yes.
Number one, they have to have actual knowledge and subjective awareness of the risk of harm, and then they basically have to ignore that risk.
Right.
So, in other words, they basically have to confess that they wanted the guy to die, and in order to convince some judges, you've met that standard.
Correct.
My argument is it's obvious. A jury could find that they had actual knowledge because they were there and it was there, and you can infer that they knew the risk, whether they admit to it or not. And then the question is, if they in fact were aware of that risk, was it reasonable for them to do nothing about it? I mean, that's basically that's the best I can do to convert a subjective standard into an objective standard, and it works about 1 out of 10 times. I think I've lost the majority of the jail suicide cases I've had. I've either lost them or settled them once I got by summary judgment.
Let's talk briefly about your other United States Supreme Court case, Scott v. Harris. And that was and just for our listeners, the site is 550 U.S. 372, a 2007 case. That was an excessive force case involving a vehicle chase. And we're going to put there's video of that chase, I guess the dash cam video from the officer's car. And it was interesting when I was reading that, because a lot of the decision in that case centered on how to interpret that video.
Yeah, and that was absurd. When
so we're going to put that video on the website.
When judges are arguing about how to interpret a video, you've got a jury question. Plain and simple.
Makes sense.
And the one judge, Judge Justice Stevens, who went my way in that case, was extremely outspoken about that. He actually spoke at the Georgia State Law School after that case came out. I didn't hear it, but I was told that he mentioned that case as an example of how the court had become politicized and certain justices were making outcome determinative decisions, coming up with whatever logic they needed to justify an outcome that they already thought was appropriate, whether the evidence was disputed or not. And I don't know if you're going to show that video or not, but
we're not going to show it right here, but it'll be on our website for viewers, so they can.
Let me say this then. There's a great article. There's a great article in the Harvard Law Review. I don't read it, by the way. I know they read it up in Cartersville. But January 2009 edition of the Harvard Law Review, there's an article about Scott v. Harris, and they call it Taking the Scott Challenge. A bunch of psychology professors showed the video to several hundred citizens, and without giving them any explanation of the legal principles or the underlying facts, they simply showed them the video when they asked them, do you think that the police acted appropriately in this case? 2/3 of the people said, yeah, he was running for cops, he wouldn't stop, they acted appropriate. 1/3 of the people said, no, that wasn't appropriate. They didn't need to knock this guy off the road for speeding. I mean, they had his license tag. They could have followed him home. He didn't need to. And of course, they didn't know the rest of it. They didn't know he was a quadriplegic. They didn't know he was being stopped for going, 73 and a 55. They didn't know he was just a panicking kid who wanted to get home because the last time he'd got stopped, they impounded his car and it cost him $400 to get it out, and his mom's trailer was 2 miles up the road. And if he would have surrendered when he got there, and if he hadn't, they would have found him there anyway because they had his tag number. But anyway, what that shows, though, to me, the fact that hundreds of people can look at the same piece of evidence and interpret it two different ways without the rest of the information and without the opportunity to discuss it among each other and reach a consensus. That shows the beauty and the value of the jury system. That is a case that clearly should have gone to a jury. And maybe the jury would have decided it was appropriate. Maybe the jury would have decided it was not appropriate. It wasn't worth it. They had other alternatives. But the Supreme Court shut that down completely. They simply said, there's only one way to look at this video. Yeah. And what was ironic to me was they used the word belied, which I can't stand. It's almost like if you say something belies something, it sounds to me like you call me a liar. But what they said was that the plaintiff's version, the plaintiff's account of the incident was belied by the video. Well, guess what? The plaintiff's account of the incident was the video. He had no recollection. He was a quadriplegic. He was knocked unconscious. He had no memory of anything. The only evidence that existed was the video. And you could look at that video and you could interpret several different ways. And that, to me, was the most offensive thing about the decision. And it's ironic that this case, based upon your statistics, this case has been cited twice as many times as Hope has.
Over 45,000 times it's been cited.
Which means a couple things. One, it shows that plaintiffs lose more often than they win in these cases. So the decisions against the plaintiff are going to be cited more often than decisions for the plaintiff. But the most oft quoted part of that decision has nothing to do with the Constitution. It just has to do with the video. If the video shows you something that negates the credibility of testimony, then they can ignore the conflicting testimony and just look at the video. The irony behind that is if you have a video that shows a cop behaving badly, then the cops will say, well, the video doesn't tell the whole story. They'll say that, it's not the right angle or it's been tampered with. It's just unfortunate that that's what happened in that case. Go ahead.
I'm sorry, but in Justice Stevens' dissent, he even talks about that it's a so-called chase. It's not much of a chase. Your client used his turn signal when he went around cars, but it's on a country road. And Justice Stevens says for folks who grew up driving on country roads, 2 lanes, every time you pass a car, you have to make that kind of, especially at night, that decision. Wow, am I going to hit another car when I decide to pass this car? And I grew up on driving as a teenager on country roads.
Well, and it's also night, and you can see headlights. You can see a car a mile before it gets to you. And one of the biggest disappointments in my life was that Ruth Bader Ginsburg went against.
Yeah, I couldn't believe that either.
And she said that it was very frightening. I bit my tongue. I wanted to say, yeah, but that's because you grew up riding taxi cabs in Manhattan.
Correct.
But which is pretty, in my experience, is even more scary. But what I did say, and I probably shouldn't have said it, but I said, well, we wouldn't want you on the jury then, Justice Ginsburg. And I meant it to make the point that, well, jurors may look at this differently, and this is a jury question. Sure. Justice or Injustice Scalia, whatever you call him, Justice Scalia, not one of my favorites. He said it was the most frightening chase scene he had ever seen. He had seen since this is an oral argument. He said the most frightening chase scene he had seen since the French Connection. And later on, after. It's like there's a George Costanza episode like this on Seinfeld where later on you think of all the cool things you should have said and wish that you'd said. I wish that I'd said, well, Judge, I'm from Georgia, and And to us, it looks more like Smokey and the Bandit. And that's kind of what it was. I mean, this is just a dumb kid going 73. And here's the saddening about the whole thing. If the kid had simply slowed down, they wouldn't even going to ticket him. The cop that saw him, that initiated pursuit, saw him going 73 and a 55, flashed the blue lights at him, hoping he would slow down. My kid's got the radio blasting. He's not paying attention to anything. He didn't even know the cops behind him until he'd been behind him for a couple miles. But if he had just slowed down, that would have been the end of it. And now the kid, not only did he end up being a quadriplegic at the age of 19, I can't remember if I think he's a partial quadriplegic. He's more than a paraplegic. But anyway, he died a few years later from pneumonia due to complications from his paraplegia. And, I have to wonder, if I'd won that case, maybe his circumstances would have been better. Maybe he would have got better care. Maybe he wouldn't be dead today. These are the kind of things that you wonder about as a lawyer. I had a case where I sued a cop in Gwinnett County for beating up my client in the DUI toximeter room at the jail because my client mouthed off at him. He broke his ribs and collapsed his lung. Took him down to the floor. Jury ruled against my client. They ruled against me. And a few days after that, the cop's brother, who was also a Gwinnett County cop, murdered a woman for her insurance money. It was a high-profile case back in the late 80s.
I remember that.
And he hired the same lawyer to represent him in the criminal case, Walt Britt, that had defended the officer in my case. And I wondered for years, if I had won that trial, would this cop's brother have killed somebody? Would he have thought he'd get away with it?
Well, I mean, you're a kind, compassionate, caring person, obviously. You do. But you can't speculate. You can't put that on your shoulders.
But I understand. But it is important that you know that everything you do has consequences.
For sure.
And that it's important that you try to get things right because the consequences may be good, they may be bad. I've gotten money for people who have thrown their life away, literally killed themselves with that money. I've also had some really inspiring stories where people have bought homes and they have started businesses and they have turned their life around because of money that I got from them that would not be life-changing for me, wouldn't have even covered my taxes, but it's life-changing for them. I had a woman whose son was killed by a police officer who emailed me out of the blue 20 years later and said that the money that I got from you, I went to seminary, I became a minister, have my own congregation now. And she said, there's not a day that goes by that I don't think about what you did for me.
Well, that's a proud moment.
That is a proud moment. And
that's awesome.
That almost makes up for, some of the others.
That's a great example of why we do what we do, Craig. Craig, we've enjoyed our time with you, and thank you so much for talking to us about governmental liability. But, we ask every guest at the end, how do you define justice? What does justice mean to you?
Well, to me, personally, justice means doing for others what you would want done for you. I mean, basically, that's the golden rule. But ironically, we're not allowed to argue the golden rule to juries, maybe because there's a fear that, oh my God, we'll get too much justice. But I guess the bigger point here is that justice is not a reality. It's not a process. It's a goal. It's an ideal. It's something we're striving for. And as Dr. Martin Luther King Jr. said, the moral arc of the universe bends toward justice. it's something we're striving for. And as long as we're always bending toward justice, things are okay. One of the biggest challenges we have as guardians of the legal system is to try to keep that arc from bending backwards. So whenever there are things that try to make it harder for people to access the system, or make it less fair for people in the system, or treat some people differently from others, we have to always worry about going backwards rather than forward. So to me, justice is a goal, and I don't think it's a goal we can ever achieve completely. I mean, if someone loses a loved one, they don't want the money. The money's not gonna give them the justice they want. They want their loved one back. So, compensation can only go so far, retribution can only go so far, deterrence can only go so far. But as long as we're trying to achieve justice, then we live in a just society.
Sounds good.
Excellent.
Makes sense.
Great answer.
Humans are infallible and are fallible. I'm sorry, and so is the system. I mean, and we can all point to injustices that we've seen in our career. We can point to people who deserved something and didn't get it. I've also had clients who didn't particularly deserve it, who got things. Life is not fair, but the goal is to try to make it as fair as possible and always be striving toward perfection, whether we ever achieve it or not.
Well, Craig, I would say your career and your law practice certainly is a model of that always striving for justice, and the amount of justice you've achieved with your career is amazing. And keep up the good work, I guess is what I would say. Keep doing what you're doing.
Thank you. I appreciate it. And let me just add to that, if we could try to learn from our mistakes, we learn more from our mistakes than we do from our successes. If anything, our successes make us cocky and more likely to make a mistake in the future. So we need to always, I think, be mindful of the potential consequences of what we do, and then try to make the best of whatever happens, and then take that lesson to the next case. Which means in my practice, it means I've pissed off a lot of people by telling them I don't want their case. 20 years ago, I would have taken it. I won't take it now, and I don't have an hour to explain why. But watch the podcast. What's this thing called?
See You in Court.
Watch See You in Court. I will text that to everybody that calls me who thinks they have a case that I don't have the time to talk about.
All right.
All right. Thanks,
Appreciate
Craig.
you
Again,
taking the time to talk to us.
Yeah. Again,
Appreciate
we've been
y'all.
talking with Craig Jones, guru of governmental liability, and he's going to be living in Savannah, Georgia soon.
That's right.
So thank you again, Craig.
Thank you very much.
Well, we are at that time in our program where Robin and I share some news item that we've seen that we think will be of interest to the listening and legal public here. Robin, you wanted me to go first today, and my article is actually pretty recent. It's from August 21st, 2023, and it's from Esquire magazine, and it's entitled "Who Won the Depp versus Heard Verdict." And you'll recall that last summer we were all captivated. Took, as they say in the article, took the internet by storm as the ex-couple was engaged in a public trial. Of course, if you missed that, August the 16th, Netflix has a new series, a documentary that's come out on it, and you can watch that. So there are a couple little portions that I want to mention about this article, and people can decide if they want to go watch the article or go watch the documentary or not. So to sort of set the stage there, Johnny Depp sued Heard for $50 million, and she countersued him for $100 million. They had a 6-week trial on court TV. But at the end, the jury returned a verdict for him for, I think it was $15 million, but it was later reduced to $10 million, and she got $2 million in damages. So there are a couple of things that I want to talk about here with this case, which is, and I'm going to read from the article. As shown in the documentary, the case ended after a long, painful trial where both Depp and Heard accused each other of abuse. In the end, Heard was found guilty. And this is one of my pet peeves, like I don't have pet peeves about typographical errors that people make or about their phrasing of something, but nobody is ever found guilty in a civil trial. And you and I hear that all the time. And, guilt imposes, says you're going to be punished for something, that you violated a criminal statute. And I think it's probably particularly appropriate with what we've talked about with Craig, our guest today, about lawsuits or to compensate people for wrongs that have been done to them. They're not about establishing guilt and innocence. The other thing that I thought was really interesting about this is that it tells how the case ended. And it says, Heard and Depp eventually settled in December of 2022. The actress paid Depp $1 million, which was donated to various charities. So this was a show trial from start to finish. No one received any real compensation, for or really claimed, for damages done. It was sort of a big show, and I know a lot of people watched it, and it probably got a lot of people interested in the civil justice system. I may or may not watch the documentary, but at the end of the day, this is sort of an example in my mind of the misuse of the civil justice system.
Yeah, I'm going to agree with you on that. It may have been cooked up to kind of rekindle both of their careers, maybe get them back in the news and the headlines. So I watched a little bit of that trial when it was on court TV, and it was sickening to me. So I didn't watch much, and I don't think I'll watch the documentary. But while we're talking about pet peeves about legal writing, I'll tell you two of mine. One is when a journalist says they've been awarded a settlement. Okay, you're not awarded a settlement. That's not an award. A jury verdict is an award, but not a settlement. That's one. Number two is when there is a defense verdict in a civil case, a particular writer for a local newspaper says the defendant cleared his name.
Right.
No, they didn't. The plaintiffs just didn't prove their case, but there's no clearing of a name. It's not a criminal case. He hadn't been charged with any violation of a crime. It's just the case wasn't proved on negligence. Those are two quick pet peeves that I thought of.
I totally agree with you about both of those. And, and I also think that for example, the insurance industry would love to sort of perpetuate that because, our instincts, what we have in the Constitution about guilt beyond a reasonable doubt, which is the standard in a criminal case versus more likely than not a preponderance of the evidence in a civil case, which is a much lower standard. But they want to impose a higher standard of proof and a higher level of moral culpability on rear-ending somebody,
Exactly. Well, my news article is also same date as yours, August 21, 2023. And the headline is FBI joins investigation of threats to grand jurors in Trump, Georgia case. And this is about an investigation now that's going on by the Fulton County Sheriff's Office. And now the FBI has joined in the investigation regarding death threats to the grand jurors who indicted the former president for various items, and I think 18 other people they indicted. But now on these very conservative social media places that honestly, because I'm not involved in that world, I've never heard of, but apparently there are really some conservative social media spots where these folks have been threatening the lives of grand jurors. We've known about their threatening the life of our district attorney, Fonnie Willis. And that is horrible as well. But now they're threatening grand jurors for simply taking their job seriously, trying to do justice, trying to enforce the law. It just really bothers me. But some of these threats were things like one threat put online was, these jurors have signed their death warrant by falsely indicting President Trump. Others said they put the grand jurors' names on a hit list. Now that's threatening grand jurors. I'm concerned that once the case is going to be tried by a jury, we're going to see more of that of the pettit jurors in the case. But this is outrageous conduct, in my opinion, and we've got to do something to protect our grand jurors, our pettit jurors, to say, we appreciate your coming, you're by subpoena. We appreciate your service to the state of Georgia, to the county of Fulton County. You are doing what the law requires, and we want this to continue, because if we don't, the rule of law has no chance. And this is all about preserving the rule of law.
Totally agree with that. And it's it shows too that there are people out there that believe that jurors are supposed to decide whether somebody is popular, electable, was a good president, would make a good president, legislator, whatever else, instead of looking at what the law says, look at what the person is accused of doing and deciding if there's evidence to, in a grand jury, indict them, which is a very, very low standard, or in a trial, if there's evidence to convict them. And, they just look at, well, I really like this guy and he got indicted, so all these grand jurors, they're on the hit list now. But the intimidation, you're absolutely correct. And I hope the FBI ferrets these people out, because the grand jury and the jury system is the backbone of the rule of law. And it's the thing that makes it so different from any other branch of government. It is the only branch of government where right instead of might is supposed to rule the day. And so you've got to have people who are willing to make the decision about what's right and what's wrong, and to do it without fear of their lives being upended by that.
Right. So yeah, I'm with you. I hope the FBI, I hope they find these people and prosecute them for intimidation. It's got to stop.
Yep.
It's got to stop. Well, great talk today. I think we could probably do another part 2 on governmental immunity. It's so complicated, really complex part of the law. Yeah.
You've got to figure out what type of claim it is and who it's against, which governmental entity it's against.
Hard.
And, God bless our guest, Craig, for wading through that to try to get some justice for so many people, over the years.
Absolutely. Well, that's all I have, Lester.
That's all I have. So
let me say one. I amend that.
Sure.
Our good friend, Judge Herb Phipps, has had a health issue arise, and he was on the Court of Appeals of Georgia at the time this has arisen. He's now stepped down from the court, and he's recuperating from this health issue. And I just want to send out best wishes to Judge Phipps, sending prayers to him and Connie, his wife, looking for his speedy recovery.
Yeah, and he, for those who have not heard his fantastic speech about his involvement in the civil rights era, which has the ask the question, where were all the lawyers? And I got him along with you, Robin. You were one of my speakers when I was president of the Southeastern chapter of American Board of Trial Advocates. He's literally gone all over the country giving that speech. And wish Herb a speedy recovery, and of course his wife Connie. But also, it pains me that he's not out there delivering that message, which needs to be heard, and which he delivers so eloquently. So I'm hoping he's an amazing,
he's an amazing man, walking history. And one reason I thought about it, I was watching before we taped today, I was watching oral arguments in Georgia Supreme Court, and they had an admission of new lawyers in the Supreme Court, and Judge John Ellington, another one of our friends, delivered the remarks to the new members of the new lawyers. And he talked about the speech you're talking about, Judge Phipps' speech, and he was about to deliver it to a group in New Mexico when he had this health issue.
It was an American Board of Trial Advocates group. It was the Texas.
Was it Boda? Okay.
Yes.
And he was not able to deliver it. So Judge Ellington took parts of it and delivered it to the new lawyers this morning in their admission ceremony. And one thing I'll quote from it, and I know you've heard this, he talks about courage being the most important quality of a lawyer. And he says the courage to do the right thing when everyone is watching, and the character to do the right thing when no one is watching. That just encapsulates Herb Phipps in a nutshell. But what an incredible man, and we're looking forward to seeing him again soon after a speedy recovery.
Yes, absolutely.
All right, my friend.
Well, I guess next time we'll see you in court.
Thank you for listening to See You in Court. Brought to you by the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Please subscribe to this podcast and consider writing a review. You may find related documents to this week's episode on our website, seeyouincourt.podbean.com. Please send any questions, suggestions, or ideas to seeyouincourtpodcast@gmail.com.